In South Africa, access to information is very important because it is in line with the principles of democracy, transparency, and openness. Section 32 of the Constitution gives everyone an automatic right of access to information. However, there is certain information which must not be released to members of the public. In this video, we will be focusing on instances where an information officer must not release records to the public. Under this, there are 7 examples. We'll look at them subsequently. 1. Protection of the privacy of a third party. Public and private bodies cannot release information that contains personal information. This is seen in section 63 and 34 of PIA. The interpretation section of PIA defines personal information as any information that relates to DNA, fingerprints, sex, pregnancy, personal correspondence, religion, and other instances where a person's name appears in records. Additionally, the Protection of Personal Information Act, otherwise known as POPI, has expanded the definition of personal information to mean information relating to the physical address, email address, phone number, biometric information, medical information, financial information, criminal and employment history of people. We should state that the relationship between POPI and PIA is yet to be explored, as POPI is yet to be fully enacted. The courts have also gone further in helping information officers interpret what personal information is. In Center for Social Accountability, the Secretary of the Parliament and others, the court posed 3 questions which are necessary in identifying what personal information is. 1. Does freedom of identity cover the individual's personal information? 2. Did the individual expect that his right to privacy would be protected? 3. Was there any reasonable expectation that information should be protected? The court has stated that where these questions are answered positively, then it can be said that the disclosure of such information would be unreasonable. In Black Sash Trust and the Minister of the South African Social Security Agency, otherwise known as SASSA, where beneficiaries of SASSA provided their personal information for the purpose of payment of grants, the court held that where individuals have provided personal information, that information should be used only for the purpose for which it was given and nothing else. There are exceptions to this example. 1, where the information is already publicly available to members of the public. And 2, where the third party has given his or her consent to the release of such information. 2, our second example, protection of certain records of South African Revenue Service, otherwise known as SARS. SARS must refuse to give access to its records on revenue collection, except 1, the information is requested by the owner of that information, and 2, where if someone is requesting for that information on behalf of another person, then in these 2 instances, SARS cannot withhold the release of such information. 3, protection of commercial information of a third party. Now, this example restricts public and private information officers from releasing information that will cause harm to the trade secrets or commercial and financial interests of a particular body. There are exceptions to this as well. The exception of the third party who has given his or her consent, and 2, if the release of such information would constitute, if the non-release of such information would constitute threats to the public or would cause great risk to public safety, then that information cannot be withheld by the information officer. 4, research information of third parties. If information disclosure would reveal research details about a third party or would affect or expose the subject matter of the research or the person carrying out the research, then such information must not be released to the public. An example is that of South African bureaus in 2004, where there was a request for the research information on employees that were living with AIDS. The South African bureaus refused to release this information because it felt, one, it would affect its credibility, and also this was information that had been supplied to it in confidence. So because of this, it refused to release that request for information. It refused to release those records. 5, protection of confidential information. Where, based on a contract or a private transaction between a private body and a private or public body and a third party, the body has agreed not to release that confidential information, then it is bound, it has a duty to keep that information from being accessible by members of the public. There are exceptions to this as well, where the information is already available to the public and where a third party has consented to its release. 6, protection of information in legal proceedings. In Section 39 of PIA, a public body must refuse access to records if such records are prohibited from being released by the Criminal Procedure Act. Also, privileged records must not be released to the public except the owner of the privileged records has given consent to his records to be accessible by the public. 7, protection of safety of individuals and properties. Ordinarily, public and private bodies must refuse access to information which, if disclosed, would be reasonably expected to endanger the lives and physical safety of individuals and properties. This concludes our video on instances where an information officer must not release information to the public.